Okay, hi everybody. Before we start today, I have gotten a couple of questions about how to get the Constitution a printed version, and I'm going to share my screen and thank Boyd for the suggestion. So if you go to the Secretary of State website, let me go where you first start off. sos.ga.gov. Scroll down all the way to the bottom, and you'll see contact us or send email. Wait, why does it look different? Okay, because I have to keep going. Click on contact us. You can fill this out, select office of the Secretary of State. And in the comment, you can very nicely request for a printed copy of the Constitution, of the current Constitution. And for everybody that's asked to, the recordings are going on the Constitution Party's YouTube and Rumble pages. So YouTube, Rumble, you'll find it there. And that's all I wanted to say. And I'm turning it over to you, Judge.
Well, thank you, young lady. Greetings to all of you, children of light, and all you celestial bodies. I think we pretty much got through with Article 1, Section 1 last week. So we'll dive into Section 2. And of course, all of this is online for you to read, or you may have your own versions. But under Section 2, which is titled, and this is a good place right here for those of you who are looking. This is a good place to mention that the titles of statutes and constitutional provisions, and there's a reason for mentioning this that will come out, should have come out lifetime, but it will come out now. But when you see, for example, in paragraph 1 of Section 2, origin and foundation of government, those words, origin and foundation of government, do not have any meaning, legal meaning, in the courts of this state. And I might just as well go ahead and tell you this, which I should have mentioned when we were on Article 1, Section 1. But let's see. Let me just double check here with Article 1. Yeah. Rights of persons and 12. Okay, good. It's still there. If you go back and look at paragraph 12 in Article 1, Section 1, the title of that paragraph is Right to the Court. Well, believe it or not, the Supreme Court of the state of Georgia has held in dictum now. They were talking about an entirely different issue when they started off their decision, but they all got enmeshed in a discussion about our right to the court. And the conclusion is from that dictum that you do not have a right to the courts. And the reason you don't is because of the language of the constitutional provision. It does not say you have a right to the courts. It says that your right to prosecute or defend your own cause in any court of this state shall not be obstructed. You have a right to prosecute or defend in any court of this state, but you do not have a right to the courts. Now, when you understand the degree to which the minds of lawyers and judges either evolve or devolve, then if you read the language you can understand how they arrived at that decision. That case, by the way, was Baptiste v. Yeah, there I go, having another senior moment. Oh, well. Anyway, as I recall, there's only one case in Georgia case law that's got Baptiste, so you can use that word to look it up. But anyway, they concluded that you don't have a right to the courts, but they did not say you did not have a right to prosecute or defend. So don't be surprised if you happen to go into court one day and you happen to have a lawyer, and that lawyer says, "Oh, but judge, they've got a right to my client's got a right to the courts." And the judge looks at him and says, "No, they don't." And then your lawyer's going to be at a loss of what to say next, because he doesn't understand what the Supreme Court held and why they held it. But at any rate, that is just to illustrate the point about the captions that are assigned to these various paragraphs. Now let's see if I can get back to Article 1, Section 2, Origin and Foundation of Government. And here you can see that the people of the state of Georgia have made it plain, and keep in mind, this document exists at the will of the people of the state of Georgia. Not your legislators, not your governor, but the will of the people. And in there, they make it plain that government exists based upon the will of those who are governed. That's us, we the people. Now, for those of you who are using, I didn't think to look for this in these judicial decisions. And I right off the bat, I don't see it. But anyway, that takes care of the origin instruction, and then origin and foundation. And then in paragraph 2, we see that the objective, the object of this government, why does it exist? That is expressed in paragraph 2. But now there is a little phrase here that I want to call your attention to.
Excuse me, Judge Nally, can you share your screen so that we can see what you're reading?
Now, wait a minute, young lady. When I took this job, I did not mean to impress anyone that I knew what I was doing with a Zoom screen.
All right, no problem. Maybe I can.
I know there's a way it can be done. I've seen it done. I just haven't learned that yet. After all, I'm 77. It's hard to teach an old dog new tricks anyway. But for those who are using the LexisNexis online version, which I think I had included a link to that. But at any rate, paragraph 2 states that the people of this state have the inherent right of regulating their internal government. Government is instituted for the protection, security, and benefit of the people. And at all times, they have the right to alter or reform the same whenever the public good may require it. Now, I know that somewhere in our society, there is a small group of individuals who believe, without fail or exception, that the only way, bear with me just a second and let me Kelly, I'll have to call you back. Bye. Y'all excuse that. That's the West Coast calling. One of my favorite gold diggers from out there in Northern California. But anyway, they are discontent with the existence of the government. And most of them, by right, do harbor those feelings because they have been abused by the government. But unfortunately, some of them think that the only way to do that is to resist by force of arms. And a good example of that was the January 6th march. Now, I will grant you that that mass of people were infiltrated by ne'er-do-wells who carried out acts of vandalism, may have carried out other acts that were illegal. For the most part, most of them seem to just be content with walking around, looking at all the scenes, and trying to impress by their numbers upon the Congress of the United States that they'd had absolutely no confidence in the legality of the election. Which, of course, they were right, but I would remind each and every one of you that there is a civilized method by which we can revise and alter our form of government. And they're just the same instrumentality that is used for that is also used to keep our elected officials within due bounds. We have, with the advice and consent of our neighbors who are sworn to serve as grand jurors, we have that authority to hold our public officials to transparency and to accountability. Both. We can get both from the grand jury. Now, maybe some of you here today have served on a grand jury. Most of you may not have. But the only thing you really need to understand is when you're called and sworn as a grand juror is to do your best to view whatever evidence, whatever complaint is brought before you and the evidence accompanying it with impartiality and detachment as best you can. Now, does that mean you're not going to harbor some bias or prejudice? No, it doesn't. You can't help that. I mean, you take that every day of your life. But when you do take the oath and you do get into your courtroom, just try to remind yourself, okay, now I have to try and be impartial and detached in order to view the evidence, listen to the testimony, and reach a truthful conclusion as to what the evidence shows me. And that, by the way, is for you and you alone. It doesn't apply to your neighbor. Your neighbor may see a piece of evidence in an entirely different light than you do. But of course, that's what comes out of deliberation at the end of the presentation of a case. Once the case in chief is made and all the lawyers light out and go get them a cup of coffee and a donut, that's when you as the grand jurors sit down and share your perceptions of what you have just seen, your understandings. So at any rate, keep in mind that before we turn around, reach up over the mantle and take down the Second Amendment if we have not apprised ourselves of the use of our grand jury. We have not yet completed our duty. So at any rate, now, so that will conclude our look at paragraph 2. And then paragraph 3. This one is important also. The legislative, judicial, and executive powers shall forever remain separate and distinct, and no person discharging the duties of one shall at the same time exercise the functions of either of the others, except as herein provided. So there are exceptions. Let's see, we've got paragraph 3. Okay, now, where paragraph 3 is concerned, and if you want to make a note on something to research at a later date, you can put down the doctrine of the separation of powers. And the doctrine of the separation of powers is just a phrase which incorporates what has just been stated here in paragraph 3. A judge will not do the duty of a legislature. The legislature will not do the duties of the courts as they are established in Article 6 of our Constitution. Nor will the executive branch perform any of the duties of the other two, except where they are permitted. For example, rulemaking, executive orders, things of that nature. Oh, thank you. Now that's convenient. Now we're going to come to this little story that I was telling you about that you might find of interest. I don't have a clue how all of you feel, fortunately, people here don't feel, we think. I don't know what all of you think about the COVID situation that we've just come through and are still going through. But it happens that in the state of Oregon, there's a physician who started uncovering evidence of malfeasance, alleged malfeasance, on the part of Fauci, the CDC, several government agencies, and he was joined in his discontent with 2 Oregon state senators. And those 3 individuals started out by making a list, as it were, of their grievance about a lot of things that were going on that didn't need to be going on. And they decided, and how they reached that initial decision, I don't know. I'm not privy to that. But they decided that what they needed to do was to present the evidence they had at the time to a federal grand jury. And the way they initially went about it was they sent a letter that outlined the predominant claims that concerned them. And they mailed them to all 94 United States attorneys, every jurisdiction. And what happened was as I recall the story, what happened was one of the U.S. attorneys forwarded their complaint to the U.S. Department of Justice. And then after they had not heard from anybody in the United States government, they also sent a letter to the U.S. Department of Justice. Well, right there started a legal problem. And the problem is this. Under 18 U.S.C. 3332, all United States attorneys and all assistant United States attorneys are required upon notice. Now, that notice can be verbal or it can be in writing. In their case, it was a written notice. Please take our information and show it to a grand jury. That's all they asked. They didn't ask for criminal indictment. They just said, take our information, show it to a grand jury, let a grand jury decide what to do with this information. Well, those attorneys, all 94 United States attorneys, did not provide their grand juries with that communication. To this day, those grand jurors who were in session 2 years ago have no idea that 2 state senators and a physician out of the state of Oregon were standing at the door knocking. Well, one thing led to another, and as most people who don't get heard, they got ticked off. Well, by God, somebody is going to answer. I may not like the answer, but somebody is going to answer. And they hire a lawyer, and the lawyer says, well, yeah, you've got a right to a response. Whether you like it or not, you've got a right to that at least. Okay, fine. Well, they ain't answering, sue them. Well, the attorney did. And he brought a case in the district court at Portland, Oregon, for the District of Oregon. They have one district court, and they have, it's either 3 or 4 divisions within that court. Well, of course, not being familiar with grand jury procedure, he didn't understand that he probably should have made it a pleading ex parte. In other words, requesting the judge to assist these petitioners in getting their grievance to the grand jury. So what he did is he made a federal case out of it by claiming that there were parties respondent to his complaint. Well, of course, that upset the parties, who happened to be government agents and department heads. Didn't make Fauci the least bit happy. But lo and behold, the U.S. Department of Justice jumps in to defend them. And they file this brief responsive pleading answer back to the district court, and they raised their objections. Well, these people can't be prosecuting criminal cases. That's for the U.S. Department of Justice to do. Now, you got to keep in mind, they did not address 18 U.S.C. 4, which makes it the duty, a statutory duty of every citizen who has knowledge of violations of federal law to make that information known to some officer of the government. Well, guess what? Grand juries are officers of the federal government, just like they're officers of our courts here. Officers of our government here, excuse me. But, you know, that was an argument they didn't think they needed to make. Well, lo and behold, Judge Hernandez agreed with them and reached over into an old, I think it's a 1964 case, Linda R.S. v. Richard D., and went over towards the end of Justice Thurgood Marshall's written decision, found a sentence in his paragraph where he was talking about the power of a citizen, the lack of power of a citizen to compel a prosecuting attorney's direction in a case. And in support of that concept, which, by the way, that's legal. That's a valid concept. All prosecutors have prosecutorial discretion. Every one of them. I'm not arguing that. Wouldn't dare argue that. But what they did is they reached in and pulled out this one sentence, and that one sentence said that in American jurisprudence, a citizen lacks a judicially cognizable interest in the prosecution or non-prosecution of another. Now, Justice Marshall was making that statement in support of the concept you can't compel a United States attorney. And Justice Marshall was absolutely correct, but here's the problem. Now these people, and several thousand, by the way, from the time that decision was made until today, I know there's over 1,600 potential criminal cases that have been concealed from grand juries in which criminal activity was alleged. But the grand jury never heard about it because the judges went back and pulled out that one sentence out of context and looked at those people and said, you don't have the right to prosecute anybody in this country, which was in clear violation of the early English and early American common law acknowledgments of courts, where all courts in those days understood, yes, a citizen, not only, and as it was stated in a Georgia case from 1886, Justice Hall wrote, it is the right of every citizen or individual of lawful age to come forward and prosecute for offenses against the state. That judge, ladies and gentlemen, just said that if you want to prosecute a crime that you have knowledge and evidence of, you have the right to stand in the place of a government prosecutor. You can walk into the courthouse and tell the district attorney, go get you a cup of coffee and a donut, prop your feet up, and grand jury will call you when they're ready for you. That's the kind of power you as a citizen have. You want to know who in the hierarchical structure of power in this state has the most power, who is the most powerful entity under our Constitution. Go look in a mirror. But anyway, so instead of acknowledging the authority of those two state senators, who, by the way, had a little additional authority because they were coming to the court in their official capacity, and the doctor was coming in his individual capacity. But rather than do that, he also ignored the plain language of 18 U.S.C. 3332, which compelled the prosecuting attorney to inform the grand jury. The law doesn't ask the U.S. attorney whether or not you want to prosecute it. You must take it to the grand jury, but they refused. Then the judge comes around and supports that by taking this concept out of context in the case of Linda R.S. v. Richard D. And then he goes even further, because the United States Congress in 28 U.S.C. 1861 says plainly any person having a right to a trial by jury shall have access to the federal courts and, black letter law, the grand jury. Congress has made it plain. You have a right to the grand jury in person. But the judge wasn't happy with that. He ignored it. He didn't even bring it up. Nor did he bring up Federal Rules of Criminal Procedure, Rule 6, which is very specific and pointedly directed at the jurisdiction of a judge when summoning a grand jury. Doesn't matter whether he's summoning a brand new venere or if he is summoning a grand jury that is already in session so he can charge them, or he's bringing in a grand jury that is in recess so he can charge them. It doesn't matter. As long as he's summoning, there is only one question Congress has given him authority to address, and that is it in the public interest? And the judge didn't even answer that question. Judge Hernandez just ignored it. Instead, he goes off on a tangent and rules on a whole bunch of other practices and procedures that didn't mean squat to that case. So anyway, the bottom line, that case has now gone to the Ninth Circuit Court of Appeals, and we have all been busy working on the last brief to be filed, which is to be filed Monday. But if this question ever gets back to the grand jury, it will be a question of, was there malfeasance in the manner in which pharmaceutical companies, government agencies, and others colluded in order to bring harm to citizens of this state and nation. And right now, ladies and gentlemen, I am aware of one piece of evidence in that case, which is a study of the death records from 2015 until the present in the state of Massachusetts. And it is, I can assure you, it is unconscionable at the number of deaths that can be statistically linked to the jab, the vaccinations. As a matter of fact, I've just learned this past couple of days that a very dear friend of mine and my wife's a teacher used to be in Cobb County, and God bless her, she suffered a stroke, and her attending made a comment to her about the nature of the types of clots that they removed from her brain. So anyway, I'm sorry I went off a little bit on a tangent there. But it's important to understand this. That judge did, by the nature of the manner in which he reached his decision, he abused the separation of powers clause. And that is, by the way, one of the issues that is being raised in the Ninth Circuit Court. And the reason that he abused it is because he took himself and interposed his office for the office of grand jury in determining whether or not the petitioners had standing to appear before a grand jury. And the reason he did is because he is an Article 6 court, and the grand jury is a Fifth Amendment court. There is a difference. There is case law from here to the past, which says that the grand juries are independent tribunals. They are not the property. You, when you are sworn in as a grand jury, a grand juror, you are not the property of the Superior Court. You are not the property of the district attorney. They cannot tell you where to go, when to go, or how to go. That is strictly your decision. Now, can you ask them for advice and consent? Well, absolutely you can. But you can also pick up the phone and call me, for example. And you can ask me, say, hey, the judge said we could do this, and the judge said we couldn't do that. What do you think? Well, yeah, you can do that. And yeah, you can do the other too. And here's the case law supporting it. I mean, that's the way I'd handle it, but you have also the right to express your opinion about the law. And the beautiful part of, as I pointed out the last time we were discussing the Article 1, Section 1, Article 1, Section 1, Paragraph 11, you are also judges of the law. If you don't like any of our explanations, mine, the judge, or the district attorney, then you're free to judge that law and determine for yourself, what exactly is this telling me to do, that I should do? Is it even good law? If it's not good law, we're going to nullify it. You have that authority as a grand juror. You also have that authority as a trial juror. If somebody's charged on a crime, you listen to the facts, and you all of a sudden it dawns on you, wait a minute, I believe all these facts. Yeah, I understand that this individual did that, but this is bad law. They shouldn't be enforcing this law against this individual. What do? You nullify it. You come back with a not guilty or no bill if you're in a grand jury. So anyway, I really hope all of you understand the significance of you as a true sovereign of your nation and of your state being called to serve on a grand jury. Now, I've been talking a little bit too long, and I'm missing a few sips of coffee. So I'm going to take this opportunity to see what question Dr. Nancy W. has.
Yes, Judge, thank you. A couple of us have questions about the separation of powers.
Yes.
Is that really something? My question is, these election boards in the counties, we are going tomorrow to Chatham County election board. Now, are these legislature, executive board, jurists? What are they? What branch of government are these election boards?
They're executive. They're executive agencies in essence. That is what they are.
So that's why they listen to the Secretary of State. But if they are misled by the Secretary of State, then what? They can be independent, right?
Hold on. Honey, you're touching on a really fiery topic right there. Let me explain something to you about the law. We have in Title 1, oh boy. Okay, now I got to go from memory, and I hate doing that. Title 1-3-6. I hope to the Lord that's the correct site. And what that statute does, it deals with what do you, as a citizen, have to do when a statute is passed by the legislature and then signed into law by the governor. What have you got to do? Well, that particular statute says you will take notice thereof. Now, what does notice thereof mean? It means you better go read the thing. You may not remember it once you're through reading it, but at least you read it. Part of it might stick, but at least you'll have read it. Well, it just so happens that the next sentence after that first sentence about taking notice thereof, the next sentence says, ignorance of the law excuses no one. Oops. Now, stop and think for just a minute. You're sitting on that board of elections. You've got a question about whether or not to release the actual ballots for Voter Georgia to come in and do a hand count. Let's say the Voter Georgia petitions you and the board, the rest of your members, and they want to come in and have those ballots set down in front of them and start doing a hand count for every election on that particular ballot, whether it's be a senatorial race, congressional race, or a local race. And you don't know what the law says. So you pick up the phone, you call up to Brad's office, and some lawyer up there is going to tell you, no, you let somebody touch them ballots, it's going to cost you $5,000. Now, that's what a lawyer told Cherokee County Board of Education, Board of Elections. Well, guess what? That lawyer was a liar. So you take what Raffensperger's office said, and you come into that meeting at 6 o'clock at night, and one of your constituents jumps up, I want to count the ballots. Well, no, you can't do that because Raffensperger said we couldn't. Now, what has happened? As a matter of law, what just happened? First thing is a citizen made known their desire to do a lawful thing. You, by stating that you had the information from Raffensperger, you couldn't allow it. Well, here's the problem right there. You have just violated your oath of office. Which means go pack a toothbrush and a towel and a bar of soap on a rope, because, you know, if your grand jury don't like what you've done, you're about to get a vacation you didn't want. And the reason for it is because the law commands you to know what that statute said. It's okay for Raffensperger's bunch down there, them deceiving. Never mind. Y'all about to put me on the stump. It's all right for them to tell you, no, you can't do that. The law says you can't do that. It's okay for them to tell you that. But it ain't okay for you to take their word for it. It is your duty as a board member. Go read the statute yourself. Then if you agree with them and you get a vacation for 5 years at one of Georgia's plushly appointed long-term care facilities, you know, it's all on you. It's going to be all on you anyway. The difference is what you thought was the law ain't the law, as opposed to, well, I didn't even know the law in the first place, and I was just doing what I was told. You know, this old falling back on this old crutch of, well, I was just doing what I was told. Well, that is exactly the same words that were pled at the Nuremberg trials by the Nazi officers and the doctors and the guards. We were doing what we were told. Sorry, that don't cut it. You have a duty to mankind you have a duty to yourself to know exactly what you can and cannot do within the limits of the law. So there was another issue there that I needed to bring out now, and I've done forgot it, and I apologize to y'all. I hate losing my train of thought this way. But ask your board members, have you even read the law? Can you tell me which paragraph in that law says you cannot do this, that, or the other? I mean, tell me. I'm sitting here, I have read most all of the Title 2, Title 21, Chapter 2. I don't see what you're saying is there. So you tell me where it is. Well, I can't do that. Well, if you can't do that, then you might ought to try taking my word for what the heck's written in the black letter of the law. Tell these people that, talk to them. And if it sounds like to you or to your neighbors that you're speaking demeaningly of them, yeah, you probably are. But I'll tell you one thing I've learned, 77 years, one thing I learned, I am an ardent supporter of Brother Dave Gardner and his theory on how you treat folks. And it was real simple. When a man's down, kick him. It might give him the incentive to rise above it. So, don't treat these politicians with kid gloves. They are your servants. Wait a minute. Let me rephrase that. There are two types of people in our Constitution. One is a constitutional superior. That's you. The other is a constitutional inferior. That's them. If they want to be a superior and you're equal, they need to leave that office. Just get out of the office and you're back in your chair at the board of directors. Lord of mercy, folks. I wish y'all wouldn't get me wound up. Well, let's see if we can move along here because we ain't got a whole lot of time. Oh, good Lord. Folks, I apologize. I didn't realize I'd burned up this much time running my lips. Well, let me see. Okay. Section 2, paragraph 4, contempt. 5, what? Okay, here, acts that are void. Now, see, right here, acts that are void. You need to read that. There's just 5 little paragraphs there. You need to read them. You need to understand them. Because if you do read them and understand them, and now that we're talking about elections, you're going to find out that Raffensperger is one of the claims he is making is, oh, the legislature gave me the authority to control elections. No, it didn't. Yeah, it did say he was in charge. I won't argue that a bit. But our Constitution is explicit. Only the legislature makes the laws. So his authority to be in authority where elections are concerned is circumscribed by, first, the Constitution, and secondly, the laws made by our state legislature. And guess what? There ain't a law in our election code anywhere that authorizes the printing of a QR code. There is not. As a matter of fact, if you go to 21-2-2, subparagraph 7.1, you're going to find out that it is extremely restricted as to the kind of software that can be in the BMD. The BMD is supposed to be able to print a ballot. It is not supposed to be able to print and put on your ballot a QR code. And by the way, speaking of that QR code, when you look at the contract, which, by the way, the fact that that contract requires the QR code in Exhibit B, subparagraph 3.1, that is an illegal provision in that contract. it should have been challenged. As a matter of fact, you can raise that challenge to your Board of Elections. There are two challenges you can make on election to have been into your Board of Elections. And you can demand that they go to court and get a court ruling, because you're not going to take their word for what the law is. You want a judge to say what the law is, or you want your neighbors on the grand jury. So tell them they got a choice. You can either go into Superior Court or you can go to the grand jury. We don't care which. We just want somebody to look at that and say, is that a voidable provision in that Constitution? When you look at the state law on one hand, you look at this contract provision on the other, is it authorized? If it ain't, it don't need to be there. Take it out. When you take it out, now you do away with the QR code. It disappears. Now all you get is an English language selection made by the elector. And if the tabulators can't read that ballot because there's no QR code on it, that's okay. Just hand count them. Now you can hand count the ballots. But anyway, you can force them to have to deal with the question, is that contract provision first, is it void? Call you back. Is that contract provision void? And then you get to ask them another question. And that question is this. The state law was made plain to everybody in the state on April the 2nd of 2019. Governor signed it into law. At that point, by the next morning, everybody should have been familiar with the election code of the state of Georgia. Come along 4.5 months later, and now Raffensperger and Polis, or whatever his name is, they sit down and sign that contract. And guess what? The contract is not changed throughout the last 4.5 months. They left that provision 3.1 just like it was. Now, why did they do that? Is it possible that the making that contract executable and executed on August the 12th of 2019, was it possible that was for an illegal purpose? Well, now that's a question for a grand jury. That's also a question to prove in a court of law in the Curling v. Raffensperger case. But here's the thing. If it was for an illegal purpose, and the clear presumption is that it was, because they didn't change it. They left it like it was. They didn't change it. So we can only assume that that provision was left there to create a fraud upon the people. Now, if it's a criminal provision, if it was executed for a criminal purpose, the whole contract now is voidable, and void ab initio, by the way. Now, you want to know if it was for an illegal purpose? Well, ask yourself this. If you pick up your ballot, the BMD spits out your ballot, you reach over, pick it up, and you look at it, and right up here at the top is that QR code. You can't read it. You can't verify any information contained in it. And below it is your selections. Which one of those is counted by the tabulation device? You're right. It's that QR code. That's the only one tabulated. Well, what does that mean as a matter of law? I've got my ballot selections right here, and I've got this QR code, and I don't know what it's got on it. Guess what? You just got that printer just handed you, it just spit out on an official piece of government paper, 2 ballots. Where in God's name in Georgia law are 2 ballots authorized to be printed on 1 ballot piece of paper? Where? Nowhere. There is your illegal cause. It was to perpetrate a fraud upon the people of this state. And by the way, those are legal arguments that have not yet been raised in any court of which I'm aware. But they sure need to be, either a grand jury or back in Curling v. Raffensperger. Folks, I got to apologize. Y'all can get me wound up here, and I can't seem to get through this Constitution. But I see we've only got about less than 15 minutes, so I guess we might ought to get to some questions. Would whoever was first, please go ahead with a question. Or Tanya, were you paying attention to whose questions was up first?
Amanda was first. So go ahead,
Okay.
Amanda.
Thanks. Yeah, I was wondering, this was about a little bit beforehand, but the separation of powers, is it a constitutional violation when we have the lieutenant governor serving as the president of the Senate, but then he's acting sort of probably on behalf of the governor to kick people off committees when they stand up for, like the 3 who were kicked off when they stood up for the citizens and for an audit? Is this, I guess if we can't prove that it was coming from the governor, but we all suspect it was, is that a violation of the separate branches?
Well, it might be a violation of his duties of his office, but as far as the lieutenant governor being the president of the Senate, that's legitimate.
But then
I'm trying
have
to
a
think.
separation of powers, like if it's because he holds both a legislative and an executive position. Are other states set up this way?
Technically, yes, well, this is interesting that you would make that observation, because technically, yes, he is an executive branch officer, but he is also a legislative branch officer, but only within a very strictly limited capacity. And that is to sit as the coordinator, so to speak, of the daily affairs of how the Senate is run when they're in session. Now, and as I understand it, the only time he can make a vote as a legislator is in the event of a tie. So that, it's interesting that you would note that distinction, because apparently, yes, he is the one individual who does technically serve as both an executive function and a legislative function. However, if something should happen to the governor, then he would cease, as he ascends to the governorship, he would cease any legislative function at all and become strictly an executive officer.
Okay. Well, I had asked Burt Jones that same question because he was one of the ones who had been kicked off and when he was running, and he said, well, that was highly unusual. But he didn't think we needed any constitutional amendment. And he just said he promised he wouldn't do it.
Okay.
Anyway, but
I may not have understood the depth of your question. I do apologize.
No, that was it.
Okay.
Yeah, I was. Yep.
Okay. Now who's next?
Jason. Oh, Jason took down his hand. So Sue?
Hello again,
Oh,
Judge.
Okay, hi, Jason.
I was just doing the administrative work. I have talked to both the Board of Elections and the Board of Commissioners in Franklin County, which this county is going down into the dirt quickly. And I have requested of them to check out certain legal and illegal things, as you have brought forth and other people at Voter GA and Constitution Party have over the last year. And they specifically refuse to do so. It's not their job. Now, you used a good word. You used demand. How could I demand as a citizen without actually trying to get to a grand jury? How can I demand of these board members? I was thinking about going to the media. But I just don't know, because they have totally dishonored my request or multiple requests.
You have multiple choices. Their refusal. Okay, now I need to explain this. We got to go back. Let's go back to the Article 1, Section 1, Paragraph 2. And you need to know just as well as you know your own name what that says. And it says that the protection of the person and property of these people is the paramount duty. Actually, it starts off the other way. The paramount duty of government is the protection of the person and property. Now, keep in mind, person is singular, property is singular. That means you as an individual. It don't mean the people as a whole. It means you. Whether they protect your neighbor down the street or your neighbor across town, that's irrelevant. It is you, the person, you, your property. And that is their paramount duty. Now, if they are doing something that is placing your property or your person in jeopardy, now they're violating their oath of office. 16-10-1 is a 5-year felony, 1 to 5 years. No fine. You don't pay a fine for that one. You just go to, if you're convicted, you go to jail. So that's the first thing you can do. Now there's another little trick you can use. coming out of I've been talking too long. Coming out of contract law. And that is when that individual was running for office or submitting their name for selection to be appointed, or in any event accepting an appointment. In essence, they were entering into a public contract, a contract with everybody in the county. But it just so happens they were also making an offer to do a public function for you individually. Now, anybody who understands contract understands that a contract is a promise by one to perform for another some duty in exchange for compensation. Well, are they being compensated? Yeah, they get a check from the county. And did they promise in their oath of office to do something? Yeah, they did. So what you have is an offer to perform. You have proof that they are being compensated. The only thing not being shown here is that you individually have a contractual relationship with that person, with that individual officer. And all it takes is a little letter from you saying, thanks for volunteering to do this. Thanks for getting paid. And thanks for giving us your oath of office. Now I am notifying you officially of my acceptance of your promise to do a public work on my behalf. Now, what do you think's going to happen when they get that that notice of acceptance? Oh my
Like-
God. Now
just
I'm
like-
contracted with one individual in this county, and he can sue me under contract, not under the law, constitutional law, not under the statutes, but contract law. He can
It's just
sue
gonna
me.
happen. It's gonna happen just like
I'm sorry, I lost you. You
all
go.
five of them are gonna quit.
Well, if they quit, then who takes over?
No, it's a good one. I'm gonna put that together. Thank you, Judge.
Merry Christmas, young man. Okay, folks, I apologize. I've done run out of an hour here, and I did not get to the funny part of this, what I had planned to say. So I guess we'll have to save our humor for next time.
We'll save the humor for next time. We had Sue Sanford with a question.
Yeah, go ahead. I'm still answering questions.
Hi, Judge.
No,
Going
I'm not
back
high. No, I'm not high yet, but if you'll give me a minute.
I hear you. Going back to what you were saying about the QR codes
Yes, ma'am.
and the fact that what was in our laws were not actually, they violated our law by signing that contract. But I thought that in that the filing that Garland did back in December after the election, that he did get a ruling from one of the judges that was illegal, but we haven't gotten any any results from what they would do about it. Is that not true? I thought that was.
First off, I do not know what they have pled in the pleadings they have filed. I do not know what they have pled.
Okay.
But if anybody takes this issue either to a grand jury or to a Article 6 court, be sure your prayers include the following. One, that the provision subparagraph 3.1 is declared void and void ab initio, that the contract be found executed for an illegal purpose, and therefore the contract in its entirety is void and is voidable and void ab initio. Now, what the void ab initio means is we're going to have to live with whoever's holding office, except those that were illegally elected. And they'll have to be removed, and the previous office holder will have to be brought back. But all public officers in this state elected or who stood for election after August the 12th, 2019, are officers holding over. They are not legally elected. They are officers holding over. It's a legal term, and it's valid in this state. But it's also means that the governor will have to issue his warrant to hold an election for all of those offices. Now, whether he chooses to do it at one time or whether he chooses to break it down this month, next month, and the month after that, that's his business. Now, I'm not going to worry about that.
But you're saying if we got a judgment against the contract, that it was illegal, that's what you're saying. In the event we got that, then everybody that's currently in.
You would go back to paper and pen and paper. You'd fill out a paper ballot. Your paper ballot would be hand counted. There would be no more Dominion. All Dominion equipment would be boxed up, shipped out to wherever Dominion wanted it. The state of Georgia would be able to, and your counties would be able to recoup chunks of money. And now I will say this now from a personal perspective. I don't have a complaint using the ballot marking device. It was easily usable. Anybody can use that. And as long as it puts out a ballot that I can look at and read, just like the two I've got here, I kept two of my ballots. I got out of there. They didn't want to put me in jail, so. But I kept two of my ballots and I brought them home. They're in my custody and control. And I can show you today who I voted for and for what office on both of those ballots. But I didn't cast them because they were illegal ballots. They had that QR code at the top. And I knew whatever my selection was down here was not necessarily going to be what appeared up here on that QR code. So it's an illegal ballot right off the bat. There's
That's
no,
what but that's what I'm asking though. If that is, if we got a ruling on that, then doesn't that make, what were you saying earlier does that make everybody that's currently in office not legally voted into that office? Did I say that right?
Well, they're officers holding over until such time as their legally elected successors take office. So they've got to have a legal election. So how can that be done? The next election, I don't even know what the next election is coming up, but whatever the next election, whether it's municipal, county, or state, whatever, get your grand juries to tell your boards of elections, or it only takes one grand jury, by the way, in this state on this issue. Every grand jury, there's 159 grand juries, every one of them has jurisdiction to ask this question and make a determination. And if they were to say the contract in its entirety is void, Dominion, take your equipment and leave, then that's what Dominion's got to do. And the state of Georgia is going to have to handle the legal consequences of getting back their money and what have you. On the other hand, the grand jury could say that for the purposes, now this is going to be a bit tricky. And the reason it's going to be a little tricky is because your grand jury cannot make laws. Now, they just cannot make a law. They can recommend to the state legislature the enactment of a statute, but they can't make law. But they can invalidate law and they can invalidate contracts. And what they could do is tell the governor, reconvene the legislature for the purpose of enacting one law, and that law being an amendment to 21-2-334, and that an amendment paragraph which says that in the event the Dominion system is declared void or voidable, no, not voidable, void, then it can be permissible for your election superintendent to authorize the use of the BMD for the purpose of printing a ballot in any election, but those ballots will be hand counted. Now, that would be the simple way for a grand jury to handle it.
Mm-hmm.
But keep in mind, your election superintendent, which in most cases these days is the entire board of elections, keep in mind that they have the authority under 21-2-334 to go back to just paper ballots. You fill out a paper ballot with a pencil or a pen, and it is hand counted. Bottom line.
Yeah, but they won't do it. They're afraid of Rassenberg.
Who won't do it?
The election boards won't go
Oh,
back to paper ballot.
whoa, hon, whoa. Can you name me one public official who has ever looked at a grand jury and said, go stick it? Can you name me one? Let me tell you a little history. back in, I realize now y'all a bunch of young folks here and you don't remember the Talmadge dynasty, Eugene and Herman, but Herman Talmadge now, buddy, let me tell you that man bored with a big auger in this state. And unfortunately, his fingers in the pie of the public were the sheriffs in all the counties. And one day, the sheriff down in Liberty County got some of his neighbors ticked off because of the way he was not complying with the liquor laws. And this was back in 1953. And so them folks just finally had enough of it. And they got this local lawyer and they went straight to the grand jury. No, they didn't stop and ask the district attorney if they could go. They just went and did it. They go knock on the grand jury door. Grand jury opens the door. Come on in. Tell us your problem. And they did. And that grand jury sent an order. As soon as they heard all the evidence, that grand jury sent an order into open court for the judge to forward to the governor, Governor Herman Talmadge. Now, Herman didn't want to get rid of one of his fingers in the pie of the public down in Liberty County, but he knew one thing. He was not going to be indicted for disobeying a grand jury in that county. He wasn't going to jail for nobody by telling a grand jury to take a hike. Now, when your grand jury speaks, the whole world listens. And I'll hush.
Hey, Amanda, do you have a question again?
No, sorry.
All right. So Tara, it's your turn.
Thank you. So Judge Nally, thank you for spending time on these Sundays. I know your time is precious, so want to make sure that you understand how much we all appreciate this. My question is pretty large. I know it was referenced a couple of weeks ago about the WHO and what's the so-called pandemic treaty, but it's more so I think it's international health regulations, IHR. With these vaccines, I don't know if anybody is aware of exactly what they're trying to do with this, but the WHO is essentially trying to have international law over all of its member states included, and our government is not listening to those of us that are voicing our concerns that we don't want this, but the WHO is part of this treaty and part of the IHR's amendments that they can call a pandemic for any reason whatsoever. Monkeypox, another COVID, there's too much smoking going on for any reason, force vaccines, disallow other treatments such as ivermectin, which was, confirmed to work, remdesivir, basically Deathivir. If you know anything about it, it killed more people than it helped. But these vaccines are very scary. They have something in them called nanotechnology. And if you don't know what that is, everybody needs to look it up. It's very.
That is part of the presentation to the grand jury, proposed federal grand jury in Portland, Oregon.
Okay. With the nanotechnology.
Yeah.
Okay. It's basically, and I
understand, but I think I understand exactly where you're going with this. And let me state that as I recall, the last time this was brought up, I went later and checked, and there is not yet a treaty signed by the United States, nor approved by Congress. Approved by the Senate. Until that happens, you only have to be concerned with the possibility that such could become a treaty. But I do not believe that our Senate would sit still, even if we had 100 senators who were of the Democrat Party. I don't believe that such a treaty would be signed and approved by the United States. I really don't. However, in the event that such should occur, that's when you need access, immediate access to your grand jury for their judging of the law authority, because they can invalidate it. It can, that thing could be worded so that it met every constitutional requirement that exists in the United States Constitution, and they can still look at it and say, bad law, it's nullified, and it won't be enforced.
So you're doing a great thing talking to all of us about this, but we know that so many people have gone from knowing their rights to not knowing any of their rights, and the government has taken advantage of that, and they continue to encroach on that lack of knowledge. But if and when that time comes, and you have less than 50 or so people on this call that are starting to learn our constitutional rights, and the majority of 250 million people in this country don't.
Right. Well, what I suppose what you need to understand clearly, if nothing else, understand that your educational system, both in the state and at the federal level, has done this absolutely marvelous job educating this people to the maximum level of their acceptable ignorance. And now that you're learning, you learn, teach one, and then let that one teach two more. And pretty soon the whole state becomes educated. So share what you learn with your neighbors and your family, especially your family, especially your children. God, I hate to think of our kids getting into the next generation.
Absolutely.
Me winding up being food for worms or feeding daisies. And, my kids and grandkids going to hell in a handbasket because I left them ignorant. I just couldn't live with that.
Yeah, agreed. Okay, thank you.
Yes, ma'am. Next.
All right, Suzanne?
All right. Yes, thank you so much, Judge Nally, for all. I think the WHA was a huge topic. My understanding is that they postponed it a year. But going back to the issue of the QR code, how can I, let's pursue this. My position as a citizen is I do not want to be forced to use an illegal ballot. I consider it illegal, and I'm being forced to use it. So maybe we can pick this up another time on how to approach it.
There is an alternative now. If you want to go vote a legal ballot, you can go to the mail-in ballot. What's the phrase?
Right. At the absentee ballot.
Thank you.
Is that it?
Absentee ballot. Yeah. Now that one's not supposed to have a QR code on it, and it's supposed to be counted separately from the rest. So
Yeah, it does not have a QR code on it.
thank you.
Yeah, but there are other elements like the Albert sensors and other things in the machines that we're aware of. And I think if we tabulate all the irregularities and potential fraud that we are aware of, how can they compel us to use that mechanism?
I understand that the problem with electronic counting and transference of data from your county from your precinct to your centralized county, whatever it's called, the point where all the ballots from the precincts come into the county, then from there to the state, from the state to the nation central counting place, wherever that is, whatever name that is. All these electronic transfers are open on the internet. That bothers me. And the reason it bothers me is because we don't need to be exposing access. We don't need to incur the risk of our internet information being accessed and changed. And there is one way that might, and I'm not saying it will, but it might keep that from happening, and that is to hook everybody up on our military network, which is an intranet. I don't know that could be worked out. I have no idea of the logistics involved in doing that, but that would add a greater level of security if they were on an intranet rather than an internet. And we sure as heck don't need our information going to Germany and then to Spain and then back to maybe Brazil or Uruguay or God knows where, or China. Who knows? We don't need that. We do not need that risk. We cannot tolerate that risk. And I think our forefathers down in Chatham County made that point abundantly clear back in July the 29th, 1791, when they told the state legislature, impeach these people. Because that impeachment, that was strong. They didn't want them. They didn't need them sent to prison. They just needed them out of public service. Get rid of them. They were shunned. They were an impeachment will get you officially shunned from any political, well, not from any political influence, but it certainly will cut down on your political influence in any state or county. And so they impeached them. And then, of course, the legislature went one step further. When they found out a Superior Court judge was involved in it, not only did they impeach him, they took his citizenship. And then the U.S. Congress got involved. And they cleaned their own house, all because of one Georgia grand jury taking jurisdiction in 4 counties, which they had a legal right to do. And now you got 159 grand juries, and any one of them can take jurisdiction in all 159 counties and cross state lines. They can do it now in 50 states because of the presidential election cycle. If that hadn't been involved, they had been restricted to the congressional districts and the 159 counties. But anyway, and I'll hush and yield to another question.
Okay, last question so that we can keep on with our Sunday. Charlene?
Yes, hi. Thanks, Judge. I'm still curious, and I realize, I guess the proper process is to try to go to a grand jury, but it still slays me that we could have a ruling in October of 2020, regardless of everything else that was wrong, that we could have a ruling that the BMDs were illegal by a judge. They were in conflict with Georgia law, and yet nothing happened. We didn't pull them, and as I understand it, it was because nothing was requested when they put the case in. But not only that, the judge felt that it was too close to the election to try to change it.
Yeah,
I want to take that ruling somehow, if I have to go to a grand jury, I hope not. I would love to be able to go to my city council, my mayor, city council, who ultimately discharged the municipal elections, let's say that, and to the Board of Elections, and just say, somehow I want to find a clause that says you're not doing your constitutional duty because you are allowing illegal process or procedures or machines to use in our elections. And I can't find the way to do that without going to a grand jury. Is that the only way to do it?
No, ma'am. No, ma'am. I got to ask you a question. Are you a party to the Curling v. Raffensperger October 2020 case?
I am not. I'm
Oh.
not a signed party, no.
Oh, okay. I was hoping you were one of the coalition partners that brought that case. And if there are any members of that case on this call, what you can do is, that case, by the way, is still open.
Right.
Yeah,
And-
and Judge Nally, there might not be one on this call, but we do know of one.
Well, you can let them know that they can file an amended pleading in that case, since it's still open, and raise the very specific issues that exist. And I've got those issues broken down into a bill of particulars. If they want it, they're welcome to it. And they can raise these issues. They can raise the issue that the ballot is illegal because there are two ballots on one piece of paper.
Right.
they can raise the issue that the QR code is illegal because it cannot be verified, that it is the only one that is voted, not theirs. They're being deprived their federal rights to cast a legal ballot. So, you know, that I'll give them what I've got written up. All they got to do is just have one of the coalition lawyers put the bill of particulars in a proper pleading to join or intervene or amend a prior pleading and file it. And plus they get to tell the judge, look, we don't want to deal with delays. There are two pieces of evidence for the court to look at, and both of them speak for themselves. So you don't need a hearing judge. What you need to do is read the Georgia law as it existed on August the 12th. I mean, as it was passed on April the 2nd, 2019, and then read the contract subparagraph, Exhibit B, subparagraph 3.1. And the neat thing about this is Judge Totenberg has already ruled. On page 1308, go open that case up and go down to 1308, go down to the bottom of that page and start reading I think it's the third paragraph from the bottom. And she plainly says, here's what the law says, and here's what the machine does. And it does none of those things that are required by law. That's her words, not mine. She's already found the law. She's found the facts.
No, it just slays me that we can't do something with it.
Well, that's okay. In your case, since you weren't an original party to that case, you have a couple of choices. You can file a motion to join or a motion to intervene and raise the bill of particulars, which I'll be more than happy to email it to you. I don't think I have your email address, but
motion to join or motion to intervene.
Yeah, it'll be one or the other. I don't know which. I don't fool around in
Okay,
federal civil much.
I'll get it to you.
I like federal. Okay. I like federal criminal, but
I'll throw
hate,
somebody in jail.
you know, I'm one of those that believes in, look, let's just get the facts and set them down in front of an arbitrator or a judge and be done with it. You know, don't stand there and argue and deceptively plead garbage that doesn't amount to a hill of bean. You're just wasting time. Time for me is becoming a little bit more precious as each day passes.
Thank
Judge,
you.
I appreciate you mentioning Dave Gardner. This is Orrin Harris. I expect I'm
Hey.
the only one who knew what you were talking about, but he was my
Yeah.
favorite back in the day.
We love Brother Dave, don't we?
Yeah.
When a man's down, kick him. It might give him the incentive to rise above it. You got to admit that man had some common sense. God, I'm glad there's somebody else here old enough to remember Brother Dave.
I'm 83, so I got you beat.
Oh, you beat me, dagnabbit, you young
Yeah.
whippersnapper, you. All right, and anybody else got a question? If not, I guess y'all probably like to get off your fannies and go walk around for a little bit.
Yeah, Judge, I'm thinking let's call it a day. It's 4:30.
Yeah, it is. Good Lord. Whoa, that's way over. Okay, I'm sorry, folks.
It's all right, Judge. Thank you so much.
That's the risk you take. When you crank me up, God only knows where we're gonna quit.
Well, thank you very much.
You're more than welcome, folks. Y'all have a good one. Maybe next time we'll get through article